If you are a green card holder living in California, or if someone in your family is, then what I'm about to walk you through today might be one of the most important pieces of immigration news you hear all year. Right now, at the highest court in the country, a case is sitting before the justices that could change what it actually means to come home to this country after a trip abroad. It does not matter if you have had your green card for 2 years or 20 years. It does not matter if you fly back to Mexico, the Philippines, India, China, or anywhere else to see family. This ruling could touch your life directly. Stay with me through this video, because by the end of it, you are going to understand exactly what is happening, why California is especially exposed to it, and what you can actually do right now to protect yourself and the people you love. Go ahead and subscribe to this channel before we get into it, because the ruling in this case could land any day now, and you do not want to miss the breakdown the moment it happens. Let us start with the basics, because context matters here more than almost anything else. A green card is the official document for what is called lawful permanent residency, the immigration status that sits just below citizenship. As of recent federal estimates, there are roughly 13 million lawful permanent residents living in this country, and California has long been home to more of them than any other single state. By some federal counts, more than a quarter of the entire national total. Green card holders here build businesses, raise kids who were born American citizens, pay taxes, and in many cases have called this state home for decades. One of the core features of holding a green card, the thing that makes it meaningful, is the presumption that you belong here. When you travel abroad for a wedding, a funeral, a medical emergency, or a work trip, and then you fly back into LAX, SFO, or San Diego, you are supposed to be treated like exactly what you are, a resident coming home, not a stranger showing up at the border for the first time. That presumption is now the center of a major legal fight at the Supreme Court. The case is called Blanche versus Lau, and the justices are deciding whether immigration officials can place a returning green card holder onto what is called the inadmissibility track, which functions essentially as a deportation pathway, without already having clear and convincing evidence at the moment of re-entry that the person committed a disqualifying offense. Oral arguments happened on April 22, 2026, and a ruling is expected before the court's summer recess, likely by the end of June or the first days of July. Sit with that for a second. This is not a hypothetical debate happening in a law school classroom somewhere. This is a live, decided any-day case, and the outcome could affect the daily lives of people across this entire state. So who is this case actually about, and why should his story matter to you? Mook Choi Lau is a Hong Kong native who became a lawful permanent resident of the United States back in September 2007. He has lived in New York with his wife and son, who are green card holders themselves. In May 2012, Lau was arrested in New Jersey on a counterfeiting charge. While that case was still pending, with no conviction and no trial, he took a brief trip to China. When he returned to the United States in June 2012, something unusual happened. Instead of being admitted back into the country the normal way, the way returning green card holders almost always are, immigration officials placed him on parole for deferred inspection. In immigration law, parole does not mean what it means in criminal law. It is not about being released from prison. It is a legal category that leaves a person physically inside the country but not formally admitted, stuck in a kind of legal in-between space. That distinction sounds small, but it carries enormous weight. Depending on whether you are treated as someone who has been admitted versus someone who is merely seeking admission, you face completely different standards of proof and completely different kinds of proceedings. If you are treated as seeking admission, you can be pushed into inadmissibility proceedings, which are generally tougher to fight and carry broader consequences than the standard deportation process that applies to someone who has already been formally admitted. Lau pushed back on this. He argued that the government did not have clear and convincing evidence at the actual moment he walked back through the airport that he had committed a disqualifying offense since he had only been charged, not convicted, and the case had not even gone to trial. A federal trial court agreed with him. The United States Court of Appeals for the Second Circuit agreed too, ruling that immigration officials needed to make that determination right there at the border, based on what they actually knew in that moment, not years later after the fact. The government was not willing to let that ruling stand, and that is how the case landed at the Supreme Court. The government's position, argued by an assistant to the Solicitor General, is that border officers should not be required to have airtight, clear, and convincing evidence the instant someone crosses back into the country. Their argument is that the kind of evidentiary standards that apply in adversarial court proceedings should not be expected of an officer standing at an airport counter, and that the government should be allowed to gather and present its evidence later in front of an immigration judge. Lau's side argues the opposite, that letting the government parole someone first and only justify that decision after the fact opens the door to a dangerous expansion of power, one that could be used far beyond cases like his. Immigration advocates following the case have warned that if the government wins, every lawful permanent resident traveling internationally would have to factor in the risk of being paroled and potentially detained based on nothing more than an unproven accusation. Think about what that actually looks like in practice, especially here in California. Think about the green card holder who needs to fly home for a parent's funeral. Think about the small business owner who has to travel internationally to keep a contract alive. Think about the grandparent who just wants to see a sick relative one more time. Under the system that has existed for years, those people fly home and walk back in as residents. Under the framework the government is now asking the Supreme Court to bless, those same people could be paroled into the country over a pending charge, something that has not been proven and might eventually be dismissed entirely, and then be pushed onto a far harder legal track to defend. The justices themselves did not take this lightly during oral arguments. One justice raised concerns that this kind of expanded parole power could give a motivated administration a quiet, bureaucratic tool to make life harder for immigrants without ever passing a single new law. Other justices pressed both sides on exactly where the line should be drawn and what standard border officers should realistically be expected to meet in the moment. There is also an uncomfortable twist worth understanding. Several justices raised the concern that even a ruling in Lau's favor could backfire, because if the government loses the ability to simply parole people while sorting out questionable cases, it might respond by detaining more people outright at the border instead of letting them go home while things get resolved. That tension is part of what makes this such a closely watched case among immigration attorneys right now, and it is part of why this is genuinely hard to predict. It also helps to see this case inside the bigger picture of what the Supreme Court has been doing with immigration law this term, because Blanche versus Lau is not happening in isolation. Earlier this year, on March 4, 2026, the court issued a unanimous decision in a separate case, Urias-Orellana versus Bondi, which addressed the standard federal courts must use when reviewing an immigration judge's denial of asylum. That ruling made it harder for appellate courts to overturn those denials, requiring a more deferential standard that favors the government's original decision. Separately, the court heard arguments in late April on whether the administration can terminate temporary protected status for hundreds of thousands of Haitian and Syrian nationals, a case that could ultimately affect more than 1 million people living under TPS protections across 17 different countries, with a ruling also expected before the end of June. Taken together, these cases tell you something important. The immigration legal landscape in this country is moving fast right now, and these are not abstract policy arguments. These are real decisions made by 9 people that determine what happens to real families living in real homes across California. So let us talk about what you can actually do with this information, because I never want to leave you with something that just feels alarming without giving you something useful. First, if you are a green card holder thinking about international travel in the coming months, talk to a qualified immigration attorney before you go, especially if you have any pending legal matter, any prior arrest, or any criminal record at all. Even something minor, even something from many years ago. This case is specifically about what happens to green card holders with unresolved criminal matters when they try to come home. Do not assume your situation is too small or too old to matter without getting that checked first. Second, get your documents in order. Your green card, officially Form Y-551, should be current. If it is set to expire within the next year, start the renewal process now through Form Y-90 with USCIS and use uscis.gov as your primary trustworthy source for forms and instructions. Keep copies of your green card, your I-94 arrival record, any re-entry permits if you travel for extended periods, and documentation tying you to life here. Things like your lease or mortgage, your employment records, your tax filings. These records do more than protect you at the border. They tell the story of how rooted you actually are in this country. Third, if you have any old criminal matter, even one that was resolved, even one that was expunged, talk specifically to an immigration attorney, not just a criminal defense attorney, because immigration consequences from a past case do not always show up the way you would expect, and a non-immigration lawyer may not catch them. Fourth, stay informed. Keep an eye on this channel because we are tracking this Supreme Court case along with USCIS policy updates and DHS guidance. And the moment a ruling comes down in Blanche versus Lau, we will break down exactly what it means and what steps make sense for green card holders here. If you are watching this and you are on a different part of the immigration journey, maybe applying for your first green card or sponsoring a family member, this broader legal environment still matters to you. Evidence standards across immigration proceedings have been tightening, and immigration judges have been given more discretion in a number of cases, which makes working with someone who actually understands these shifting standards more important than ever, whether your case is employment-based, family-based, or an adjustment of status filed from inside the country. Make sure every application you submit is complete, accurate, and thoroughly documented, because incomplete paperwork is consistently one of the biggest reasons cases get delayed or denied. And in an environment where scrutiny is rising, being thorough is the single best thing working in your favor. And to anyone newer to all of this, just starting to understand what a green card even is and what it takes to get one, please know that even with all of this happening, the path to lawful permanent residency is still very much open to people who qualify. The system has real processes, and while they are not always simple, they are navigable with the right information and the right support around you. Before we wrap up, a quick but important note. Everything covered in this video reflects publicly available reporting and official court records as of June 21, 2026, drawn from sources including SCOTUS blog, Roll Call, Jurist, the American Immigration Council, and official Supreme Court filings. Immigration policy can shift quickly through a court ruling, an executive action, or new legislation, so what is accurate today could look different tomorrow. Nothing in this video is legal advice, and no two immigration cases are exactly alike, so please consult a licensed immigration attorney for guidance specific to your own situation. If this video gave you something useful, take a second to hit that like button. It genuinely helps more people find this when they need it most. Share it with a friend, a coworker, a neighbor, anyone you know who holds a green card or is somewhere in the middle of an immigration case because they deserve to have this information too. And if you are not subscribed yet, do that now and turn on notifications because the ruling in Blanche versus Lau is expected any day, and we will be covering it the moment it lands. Check the description below for links to official USCIS resources and information on finding accredited immigration legal help near you. You are not the only one asking these questions right now. Millions of people across this country, and a huge share of them right here in California, are watching this exact same case and wondering what it means for their own families. Thank you for watching, and we will see you in the next one.